Let's start now. Okay. Good morning, good afternoon, and good evening. My name is Ankit Malhotra, and I am the co-founder and president of the Jindal Society of International Law. Before I introduce our speaker, I would like to say a few words about the Center for UN Studies and the Jindal Society of International Law. Both are spearheaded and are under the tutelage of Professor Dr. Westlin Popowski, who is also the Vice Dean of the Law School. In my conversations with Professor Popowski, he's often told me that in 1953, the first United Nations Secretary General, Lee, welcomed Dag Hammarskjöld, his successor. And he said the following words, and I quote, "Welcome, Dag, to the most impossible mission on this earth," end quote. The United Nations has often been criticized and turned into a scapegoat when states fail to live up to the initial expectations of its founders. But let's also remember what Hamschel said once as perhaps a response. He said, and I quote, "The United Nations was not created to take us to heaven, but to save us from hell," end quote. The Center for UN Studies engages in projects studying the history and traditions, but also takes a transformative approach to research, teaching, and societal engagement, having in mind the latest dynamic geopolitical and technological shifts. The Jindal Society of International Law, which is a student-led initiative under the aegis of Center for UN Studies and the expert tutelage of Professor Dr. Westlin Popowski, was founded in 2020 with an aim to provide a platform to young international law enthusiasts. The inaugural address and official launch of the society was delivered on 18th of November 2020, and the address was given by Herbert and Rose Rubin Professor of International Law, Jose Alvarez of NYU, along with the Vice Chancellor, Faculty Director Professor Popowski, and a very good friend of the society, Dr. Mohan Kumar. Our fall lecture series entitled Exploring the Ecosystem of International Law builds upon the introduction given in Internationalism and International Law by the concluded summer lecture series titled Future of Internationalism and International Law. The fall lecture series endeavors to study the different contours of international law. To study and assist in this, the speakers will cover and address their respective areas of expertise based on their years of research and practice. Given the vast ecosystem and engagement of international law in it, the society aims to study the fragmentation and fertilization of various disciplines in this ecosystem. The lowest common denominator in the fall lecture series is to enhance and provide a deeper understanding of international law through international lawyers. The Society for its members is a well of knowledge and a quorum of thought-provoking discussions, which will be a resultant of this engagement with experts aimed at exploring this ecosystem of international law. Today, amongst us, we have Professor Oona Hathaway, who is the Gerard C. and Bernice Latrobe Smith Professor of International Law at Yale Law School and the Director of the Center for Global Legal Challenges. She has published essays and opinion pieces in New York Times, Washington Post, Los Angeles Times, The Guardian, and Foreign Policy. And of course, the more important pieces and the more pressing pieces in international journals, of which I am, as a student, grateful to her for. She's also served as a special counsel to the General Counsel at the US Department of Defense in 2014-15, for which she was awarded the Office of the Secretary of Defense Award for Excellence. She is a member of the Advisory Committee on International Law for the legal advisor of the US Department of State as an active member of the US Supreme Court Bar. She has earned her bachelor's from Harvard College and has a JD from Yale Law School, where she was the editor-in-chief of the Yale Law School. Before I hand over the virtual floor to Professor, I do have a couple of opening remarks as to offer from the book that Professor has co-authored with another very famous Yale Law School professor, Scott Shapiro. The book, which I have over here and I recommend to all our readers, is a masterpiece. It talks about the Kellogg-Briand Pact. It is also a treaty which can be seen as the first milestone in human decency, as the authors call it. It is by outlawing war as the norm, or in other words, the pact shifts international law from pro-war to anti-war. It did not create world peace, however, but it remains a transformative step of human events, of human history towards it. It did not end war, but it marked the beginning of the end, the replacement of one international order with another. This furthers a trend that leads into international treaties such as the United Nations Charter, and more specifically, Article 2.4 of the Charter. The authors in the preface also note what Frank Kellogg said. He said, and I quote, "This treaty marks a new date in history of mankind and the end of selfish and willful warfare," end quote. Frank Kellogg, as the authors note, also made a reference to a Roman military theorist, Vegetius, who said, "If you want peace, prepare for war." The authors note what Kellogg said as a response to it. He said, "If you want peace, prepare for peace." The authors also acknowledge that this treaty is mocked or in other instances forgotten. It is, however, responsible for the evolution of treaty making. The authors note that outlawing war seems ridiculous to us because ours is a world in which war has already been outlawed. It is difficult to imagine war serving any legitimate function other than a defensive one. Today, war is regarded as a departure from civilized politics. However, before 1928, it was war which was not a departure from politics, it was civilized politics. The pact has fundamentally altered the nature of conflict, of war itself. It has reshaped the world map, catalyzed the human rights revolution, enabled the use of economic sanction as a tool of law enforcement, and ignited the explosion in the number of international organizations that regulate so many aspects of our daily lives. But all things considered, let us also remember that the Treaty of Versailles was signed in 1919, and that treaty got bad press. It imposed punitive conditions on Germany after the First World War and is blamed for the rise of one Adolf Hitler. The Kellogg-Briand Pact does not get any press at all. That is because the treaty went into effect on July 24th, 1929, after which the following occurred. Japan invaded Manchuria in 1931, Italy invaded Ethiopia in 1935, Japan invaded China in 1937, Germany invaded Poland in 1939, the Soviet Union invaded Finland in 1939, the Germans invaded Denmark, Norway, Belgium, the Netherlands, Luxembourg, France, and attacked Britain in 1940. And Japan attacked the United States of America in 1941, all culminating in a global war that produced the atomic bomb and more than 60 million deaths. The peace of paper in Paris does not seem to have presented an obstacle to the citizens of one country engaging in the organized slaughter of the citizens of another country. All of this perhaps brings me back to what one Louis Henkin once very famously said. He said, and I quote, "Almost all nations observe almost all principles of international law, almost all of their obligations, almost all of their time." With those words, Professor, I welcome you, and I look forward to hearing your arguments to those which I have presented. Thank you.
Thank you so much. It's such a pleasure to have a chance to talk with you today. I'm really grateful for the invitation and really admire the work of your center. It's really phenomenal to see the great folks who've spoken and the important work that you're doing. So thank you for letting me be a part of that. So I am going to, in a sense, present some of the deep history of the UN Charter and to try and show why the Charter was so transformative, but that we can't really understand that unless we understand this kind of broader, deeper history that preceded it. And we tend to often, when we're telling the story of the UN Charter, start in 1945 and look just, the last 70, 80 years. But really, we have to understand why it's important and understand what it does and why some of the elements of it are as crucial as they are. We really have to understand the deeper history. So I'm going to share a screen with all of you so that you can see this PowerPoint. And I'm going to give you some overview of why the UN Charter matters so much in the kind of historical scope. And in the presentation that I'm giving, I'm basing it in part on this book that you've mentioned that I wrote with my co-author, Scott Shapiro. It's entitled The Internationalists, and it provides some of this deep history. I'm going to also go a bit beyond that, but this is the foundation for the talk that I'm giving. So if anyone wants to kind of go back and take a look at it in more depth, that's a place to look. All right, so the title of the talk is A Rise of the Modern Legal Order and the Role of the United Nations Charter. So I'm going to talk about this history and the rise of the modern legal order and the role that the UN Charter has played in that. So there's kind of three parts to my talk. The first is the old world order. So what did the world look like for hundreds of years before? And I'm going to talk you through the kind of historical perspective of what was international law for hundreds of years. Then what happened? What transformed that? What changed it? And then I'm going to talk a bit about the New World Order, which is really the post-UN world that we're also familiar with. Okay, so first, the Old World Order. We start the book with the story of this gentleman, the lovely gentleman in the picture in the upper right-hand corner. His name's Jacob van Heemskerk. He led an expedition, a Dutch expedition to the East Indies, where he was trying to buy spices on behalf of the Dutch East India Company. He and many of his fellow Dutchmen ran into trouble because the Portuguese had long established a monopoly over trade with the East Indies, and particularly spices and other kinds of rare goods that were not generally available in Europe. And the Portuguese had been attacking Dutch ships, didn't attack Jacob van Heemskerk, but it attacked some of his colleagues. And as a result, he couldn't find enough spices to buy to fill his ships. And so he had this idea, which was, well, if the Portuguese are attacking my fellow Dutchmen, and that's what's making it impossible for me to buy spices, they're also attacking any locals who will do business with Dutchmen, that's a terrible wrong to us, and we should be able to do something about it. So he and his ships, these are the small ships are being depicted in this painting surrounding the Santa Catarina, which is a Portuguese ship, quickly disabled it, towed it back to the Netherlands, sold it for an exorbitant amount of money, which his employer was very happy to take the money. That was the Dutch East India Company. He got a small percentage of it. Everybody was very happy with this result, at least the Dutch. The Portuguese, of course, were pretty upset about it. And the stockholders of the Dutch East India Company got a little squeamish about it. They were worried, well, is this really something that's legitimate, or is anyone going to raise concerns about whether what we're engaging in is really piracy? Is this legal? And so they hired a young man to write a legal pamphlet. And if you're studying international law, you've probably heard this young man's name. It's Hugo Grotius, sometimes known as the father of international law. This is a young Hugo Grotius depicted in this painting. He was hired to defend Jacob van Heemskerk in the seizure of the Santa Catarina. And he wrote this lengthy treatise. He was really supposed to write this short little pamphlet, but like any good academic, wrote hundreds and hundreds of pages, took him way too long. His employers were not particularly happy with it. But in the process, he developed this new theory of international law to justify this seizure of the Santa Catarina. Now, kind of a fun historical note, Jacob van Heemskerk happens to have been his own cousin. So he was not only working for his employer in this, he was also defending his cousin, who had also become quite rich as a result of this seizure. And in the theory that he develops in this early manuscript is this idea that war is a permissible remedy for wrongdoing. So he says, when judicial settlement ends, war begins. What he means by that is because the Dutch couldn't go to court to right the wrongs the Portuguese had done to them in the East Indies, that they could resort to war to right the wrongs that had been done to them. And therefore, the seizure by Jacob van Heemskerk was legitimate because it was simply righting wrongs that had been done. The Portuguese had tortured some Dutch sailors. They had made it impossible for them to do business. And this was a kind of reasonable response, in his view, to that violation. Now, this idea was in a manuscript that he wrote that was for a long time lost, but it becomes a core idea of his later work, which is really seen as a foundational work of international law. So he says the subject matter is the same in warfare as in judicial trials. Again, what he means is if you have the kind of claim that ordinarily you could go to court for, but you don't have access to a court, of course, the Dutch in the East Indies didn't have an access to a court, that you can instead go to war. And in a separate project, we mentioned this very briefly in the book, but separately, Scott and I and a couple of co-authors went to see, is this just something Hugo Grotius is saying, or is this something that actually states were doing? If you look at actual state practice, were they actually going to war for these kinds of reasons? And the answer is yes. So we gathered these things that are called war manifestos. And if you're curious about them, we actually have gathered a database. If you just put in my name and war manifestos, you can get this great database on the Yale Law School Library website that has all
which
of the...
which perhaps not great reputation.
Yeah, thank you. Yeah, no, it's fantastic because they're fascinating to read. Some of them are really hundreds of years old, so they're quite difficult to read. Many of them are Latin, classical Chinese. They're not all in English, obviously. A lot of them in German. If you read Fraktur, you're in luck because a lot of these are written in Fraktur. And they're fascinating because they lay out these justifications for going to war. They say, you stole my wife. The earliest one was about wife stealing. You stole my wife. That was really not okay. I'm going to go to war against you for that. And they're, of course, very flowery. Sometimes they hired like the greatest writers of the time. And really what they were trying to do was justify the war that they were about to launch to their fellow citizens, to citizens around the world, and to their fellow sovereigns. And this gives us insight into what they saw as legitimate reasons for going to war. And so what we did is we read all these manifestos, we cataloged all the reasons that they gave, and these are several of the reasons that we came up with. And again, since many of you are students, if you're interested in this, I really recommend going and looking at it. We have it all cataloged and you can go explore it and do your own research based on it. We really hope that you do. And you can see if you look at this list, some of these are reasons that you could give today, self-defense. But most of the reasons on this list are not reasons that you could give today for going to war, defending a true religion, collecting unpaid debts, disrupting the fact that the other side was disrupting the balance of power. These are not the kinds of reasons that we would consider legitimate reasons for going to war. We catalog them not only in individual instances, but then we look to see how the reasoning changed over time. So this is one of the graphs from the book where we show how this has changed over time. And you can see self-defense becomes a more common reason over time, but violation of treaties is the common reason, becomes also more common over time. So there's a variety of reasons that are given that are quite common. That today we would say, the vast majority of these are not reasons we consider to be legitimate reasons for going to war, but at the time, they were considered entirely legitimate and reasonable justifications for launching a war. So the argument that I want to make is that this privileged use force, this idea that it's okay to go to war, to right wrongs, really lay at the center of the international legal order for hundreds of years. And what I'm going to show is that several other rules then flow from that central principle. So you have the central principle that war is okay, that you have a privilege to use force to right wrongs. Then several other things necessarily follow from it. And what we'll see then is that when you change that core rule, everything else has to change as well. So let me lay that out in brief. So if war is legal, then conquest has to be legal. An example that we give in the book is this gentleman whose picture is shown here in a daguerreotype is President Polk, who launched the war against Mexico. And the justification that he gave was that Mexico had failed to repay debts to the United States. So for many years, the Mexican government was really in flux. They had, I think, 32 governments in 31 years. They were not particularly good at paying their debts. There were a number of instances where private US citizens laid claims against the Mexican government because their ships were taken or goods were stolen and the like. They had an actual arbitral proceeding where there was an international arbitrator who went through all the claims that were made and determined exactly how much was owed to the United States, and Mexico agreed to a repayment plan. So it's the sort of thing we think of as kind of a modern invention, not at all modern. It was in place in the 1840s. They agreed to this plan, they paid the first few payments, and then they defaulted. So Polk, who had wanted to take this land, it's clear he wanted this land, but now he had his legal justification. So his legal justification was Mexico has not repaid these debts. We can go to war and take land in payment of those debts. And that's exactly what the United States did. It went to war, it seized a huge portion of what is today the United States, and took it in recompense for the failure to repay the debts and the cost of collection, that is the war itself. So they had to repay the cost of collection. And then because they realized they'd sort of taken a bit more land than they were really entitled to, they, in the final treaty, also agreed to a payment to Mexico in return for some of the additional land that they had taken. Now, was there an international outcry about this? No, this was seen as perfectly normal behavior at the time. There was nothing seen as illegitimate or illegal about this practice. You conquered land in recompense for wrongs that were done to you in a war, and you got to keep it. So if war is legal, conquest is legal. If war is legal, gunboat diplomacy is also legal. This is a woodcut picture from the Japanese perspective when this gentleman, Commodore Perry, who is fresh off of the war with Mexico, US war with Mexico, arrived in Tokyo Bay, at the time Edo Bay, insisting on a treaty of friendship with Japan, which at the time was completely closed to trade with the outside world, with a rare exception of very limited trade with the Dutch and Chinese. But generally speaking, had been completely closed off from international trade and really had rules and laws prohibiting foreigners from setting foot on Japanese soil. And Commodore Perry basically said, you're going to enter into a treaty of friendship with us or else. And Japan, seeing that there was really no alternative, ended up having to agree to actually enter into that treaty. And several other European nations insisted on the same treaty, and that forced Japan to open to the rest of the world. They really had no choice. Not only did they have no choice, but to enter into this treaty, once they did so, if they violated it, that would be a cause of war, because violating an international treaty was a cause of war. Now, if war is legal, there can't be a crime of aggression. So after World War I, the Allies wanted to try Kaiser Wilhelm II. And the Dutch said, no, you can't. There's nothing illegal about what he did. Yes, he launched an aggressive war, but that is not a criminal action. That's not illegal. It's not against the law. And so we can't criminally prosecute him. If war is legal, states can't favor either side in a war. So neutrality required complete impartiality. So before the United States joined the war, World War I, Woodrow Wilson, who ran on a platform, he kept us out of war. Of course, he didn't manage to keep us out of war for very long after this, but he had been endeavoring to keep the US out of World War I. He said we have to remain neutral in fact as well as in name, that we have to be impartial in thought as well as in action. So the idea was you had to be completely impartial if you were a neutral, because favoring either side was seen as taking sides in the fight. And that was a wrong to the side that you disfavored, and that would be a cause of war against the side that you disfavored. So neutrals had to stay perfectly impartial. You couldn't place economic sanctions against the side you thought was the aggressor, because if you did that, that was clearly a violation of neutrality and a cause of war. So again, the privilege to use force lay at the core, and then the rest of these rules necessarily followed from it. Once you've got that core permission to use force, a privilege to use force, then it's a kind of logical follow-on that the rest of these rules necessarily have to be in place. Okay, so how does all of this change? Because hopefully you're thinking like, this is not the set of rules that we live under today. So then the question is, how do we get from there to here? And that's really the core argument of the book, is that something fundamentally transformative took place. So one of the key figures in the book is this guy, Salmon Levinson, who's really not a known figure at all in international law circles. I'd never heard of him. But when I tried to trace back this question, when I asked this question, when did this change? I traced it back and back and back and back and back, and eventually got to this guy, Salmon Levinson. He was this lawyer from Chicago, really not an academic, not a government official, just a guy who had this idea that what we should do to end war is to outlaw it. And he had this very powerful idea. He said that real disease of the world is the legality and availability of war. We should not have, as now, laws of war, but laws against war, just as there are no laws of murder or of poisoning, but laws against them. So this is a fundamental idea that really, I think, at least in this era, was one that he pushed. He wrote articles about it. He founded a non-governmental organization. He lobbied politicians. He not only lobbied within the United States, but around the world. He sent out postcards around the country to support this idea. He really worked hard to lobby to get this idea into people's minds that maybe this is the way that we should avoid the problems that had led us into World War I and prevent another conflagration from happening. There's another gentleman as well who's sort of thinking about these issues at the same time. And is a kind of more traditional actor in this field. His name is James T. Shotwell. He's a historian at Columbia, and he's also really interested in working to end war. He had been on a commission that had been part of the effort to try and get the US to sign the Versailles Treaty, which of course was unsuccessful. But he too picked up on this idea of outlawing war and the rhetoric of outlawing war. He saw the power of the idea, and he helped bring that idea to an international audience. He gave speeches in France, he gave speeches in Germany. We tell how some of the reactions to his speeches led to, for instance, Carl Schmitt's most famous work. So this is the kind of, he's this long, sort of forgotten figure in international circles, but he turns out to be much more important than I think is generally appreciated. So he really has this idea. He brings it to Briand, who's the prime minister in France, and says, you should suggest this back to the United States, that there should be a treaty outlawing war between France and the United States. Briand takes up the idea, and we tell the story of the kind of back and forth that ultimately does lead to what's known today, at least in the United States, as the Kellogg-Briand Treaty. Kellogg after the US Secretary of State at the time, and Briand, the prime minister at the time. And that leads to this, as I said, the signing of the pact. The signing ceremony takes place in 1928. The pact enters into force in 1929. There was this grand ceremony in Paris. There were 15 nations present that signed at the time. And then the treaty went around the world for signatures and countries. It became the most ratified treaty in the world at the time. Nearly every nation signed this treaty outlawing war. The central commitment of the treaty is that the high contracting parties, that is the parties to the treaty, condemn recourse to war for the solution of international controversies and renounce it as an instrument of national policy in their relations with one another. Now, if you look at this from our modern perspective, you might think, okay, like shrug, like big deal. This doesn't seem like this is, of course, the renounce it as an instrument of national policy. Like, who would use war as an instrument of national policy in their relations with one another? But at the time, given the history and given that war was a central way in which states righted wrongs, and it was a way in which states could pursue their legal rights, it was a really fundamental change, and it was recognized as such by the parties who joined it. So the story that we tell in the book is that this doesn't change things overnight. It's not like, okay, the treaty is signed, like we're in a completely different world now, and everybody recognizes that. There was the signature of the treaty, and that begins the unraveling of the old world order, and it begins the reconstruction of a new world order. So there's sometimes a misconception that a treaty, the minute the treaty is signed, like everything changes. And generally speaking, that's not how treaties work. They begin to change behavior of states over time. And that's true with the Kelly-Brand Pact. And what's not appreciated is that in a way, what this treaty does is it pulls the rug out from under the old world order, but they don't really know what goes in its place yet. They haven't really figured that out. And that leads to real instability and about 20 years of trying to figure out the answer to that. So as I mentioned, the old world order has a privilege to use force at its core, and everything else kind of follows from it. But the new world order has to be constructed based on the exact opposite central principle. So where there was a permission to use force, there's now a prohibition on force, and all the rest of the rules have to change. So I'm going to say a little bit about how that takes place. So the first thing that happens that really challenges the Kelly-Brand Pact is Japan invades Manchuria. We tell the story of this. It's actually pretty fascinating. The machinations within the Japanese military. It's these young Japanese soldiers who set a charge on their own railway to try and give them a legal justification to go to war against China, and particularly in Manchuria. This is a Japanese-run railway through Manchuria. And actually, as I was writing the book, a big part of what motivated my own thinking and writing was how in the world did there get to be a Japanese-owned and run railway through Chinese Manchuria? Like what led to that? That was a big part of the question that I spent a lot of time trying to unravel. I won't say a lot about it here, but this was a key event in forcing states to confront the fact that while they had prohibited war, they hadn't really figured out what they were going to do if states broke that rule. There wasn't anything in the treaty that says, okay, if states then go to war, here's what can happen. They didn't think about enforcement. They didn't come up with a way in which they were going to respond. And they didn't think about what was going to happen if states didn't follow the rules, and also how they were going to change the rest of the rules to make the system cohere. And they were confronted with that failure when Japan invaded Manchuria, because they really didn't know how to respond. Ultimately, they came up, after a fair bit of debate and discussion, they came up with a solution, which was not a perfect solution, but a partial solution. That is that they announced, the US and then the League quickly followed, that they wouldn't recognize any situation, treaty, or agreement which may be brought about by means contrary to the covenants and obligations of the Pact of Paris. So the Pact of Paris is another term for Kelly-Brand Pact. One theory I have about why the Kelly-Brand Pact has sort of been lost in history is that these crucial documents that make clear that it was an important treaty don't use the term Kelly-Brand Pact. They use the Pact of Paris or General Treaty for Renunciation of War. It has a lot of different names, and people don't realize we're talking about the same treaty. In each one of these, it's just separate names, different names that it's being referred to. So this document was really an important one for me, because this is when I was trying to figure out, when did we stop recognizing the idea of conquest? When did we say, well, the fact that you've taken territory doesn't mean that it's yours? And this is really one of the key moments in that effort to say, okay, you can take it, you might control it, but it's not yours. And we're not going to recognize it as being a part of your territory. And the League of Nations takes the same position. It's not going to recognize this territory as being part of Japan or of a puppet government that it tried to set up to try and evade these rules. So where there used to be a right of conquest, now there's no right of conquest. So that's the first kind of beginning of putting together something new. And in fact, this really works surprisingly well. So one thing that we tried to document is we tried to look and see, did this actually make a change in the world? So we can say these are changes in legal rules, but did it actually change what states were doing in the world? And we go into this in more depth in the book, but we think we've documented that the answer is yes. So while what we call sticky conquest, that is where you take land and it stays yours and you get to keep it, was around 200 square kilometers a year before, under the old world order. It's not that conquest has completely disappeared in the new world order, but they're substantially reduced to about 15,000 square kilometers a year. So there definitely are instances where there's violations of this rule, but it's a substantially reduced fact of the world that states take territory and annex it illegally, and it becomes theirs. That doesn't happen on a regular basis. It does occasionally happen. I'll talk in a minute about Crimea is a counterexample of one of the things that kind of is in the current in that circle under the New World Order, but it's much less common than it once was. Notice also that in that note, Stimson wrote to Japan and China, he said, we also are not going to recognize a treaty or agreement that's going to be brought about by means contrary to the Pact of Paris. So he's saying we're not going to, even if you can get them to sign a treaty using gunboat diplomacy, that's not good enough. We're not going to recognize that treaty. Again, this is a really transformative moment in international law, because up to that point, treaties that were brought about through force were considered perfectly fine and legitimate. And this is the first instance where they're saying, no, we're not going to accept those anymore. That becomes the foundation for the principle under the Vienna Conventional Law of Treaties in Article 52, says a treaty is void if its conclusion has been procured by threat or use of force. When that was being negotiated, one of the questions that came up was, well, is this going to be retroactive or only going forward? And of course, states who had been subject to gunboat diplomacy and signed really unequal treaties really wanted it to be retroactive. Understandably, the larger states refused and insisted that it only be forward going, because it would have basically undone much of international laws that existed to that point. And the commentary by Hirsch Lauterpacht, who's a figure in the book, I won't say a lot about him here, he explains that after the pact, insofar as war or threats of force constitute illegally international acts, so internationally illegal acts, the result of those illegalities imposed treaties cannot be considered valid, nor do they produce legal rights that would benefit the lawbreaker. But he recognizes that is new as a result of the pact. That is not how it used to be. This is a transformation that has taken place as a result of the outlawing of war. So where gunboat diplomacy used to be perfectly legal and legitimate, now there's no legitimate right of gunboat diplomacy. So neutrality. This is just one example again. Robert Jackson, who became a justice on the U.S. Supreme Court, but also was a judge at the trials, the Nuremberg trials. When he was Attorney General, one of the questions that came up was, can the U.S. provide support to the Allies before the U.S. had joined the war? Can it provide support? Can it do, for instance, what we call the Lend-Lease program, which was available only to the Allies and not to the Germans? Historically, that would have been illegal, because that was much more favoring that one side in the war over the other. And what this speech that he gave says is the Treaty for Renunciation of War, again, another word, another term for the Kellogg-Briand Pact, by altering fundamentally the place of war in international law, has affected a parallel change in the law and status of neutrality, allowing the United States to enter discriminatory trade arrangements that favor the Allies, including Lend-Lease. So he makes clear that he sees this transformation in neutrality as really tracing to the outlawing of war in 1928-29. So that was the fundamental change that made it legal for the US to engage in Lend-Lease, whereas it would have been illegal in, for instance, World War I. So where neutrality used to require perfect impartiality, you couldn't favor either side, you couldn't do economic sanctions against one side. Now neutrality permits partiality, including economic sanctions against the side you think is the aggressor in the war, which you wouldn't have been allowed to do before. Last, the crime of aggression. This is the dock at Nuremberg. I think probably most people will recognize that. Nuremberg indictment count 1 makes clear that the fundamental justification for the war is that these invasions had been specifically planned in advance in violation of the terms of the Kellogg-Briand Pact of 1928. So it makes clear that the core violation that gets the Nuremberg trials off the ground is this illegal invasion that then makes it possible to try the Nazis for the crime of aggression, which, remember, we couldn't try Kaiser Wilhelm II for World War II because war was not a crime. But now war is a crime. Why is it a crime? Because in the intervening years, Germany, Japan, the US, all the countries that were party to World War II had signed the Kellogg-Briand Pact making war illegal. So now we could have a crime of aggression. So where it used to be license to kill, no crime of aggression, now aggression can be a crime. So again, the New World Order puts a prohibition on force at the core, and then all the rest of these rules follow from it, which are transformative rules. They are different from what came before. And the key argument that we want to make is that you can't understand the whole system unless you understand that core prohibition on force. That really is central to everything else. Okay, so what's the New World Order look like? You're probably wondering, okay, what's all of this have to do with the United Nations? So that's where I'm going to get to that point. So in 1949, Sumner Welles, who's an Undersecretary of State in the US, begins planning for the end of the war. We haven't even entered the war yet, but he recognizes, look, these international institutions haven't worked. We're in the midst of a global war again. These prohibitions haven't been successful. What are we going to do to bring an end to war so that when this war is finally over, we really can prevent nations from going to war with one another? And this process, as part of that, leads to the 1941 Atlantic Charter, famously a declaration by the US and the UK that all nations of the world must come to the abandonment of the use of force. That's a central principle, reaffirming the central idea in the Kellogg-Briand Pact that we have to renounce the use of force as a fundamental policy of statecraft. That Atlantic Charter then becomes adopted by, open to signature by all of the allies in the war. And it becomes literally precisely the same text, becomes the declaration by United Nations. This is the first use of the term United Nations. So the idea is we are united together in this rejection of the use of force to change realities on the ground, to change statecraft, to change legal rights. And this then becomes a foundation for the organization that will become, you have the same name, the United Nations. This is the first time that we see this group identified as United Nations. So Welles then forms a special subcommittee on international organization at the State Department. And the job of that group is to take this basic idea in the Atlantic Charter and then the declaration by the United Nations and figure out what an international institution is going to look like that will actually make this work. So the big mistake they made in the Kellogg-Briand Pact is they had this prohibition on war, but there was no institutional structure around it. It was just basically, let's not go to war anymore. Nothing else, nothing about like, okay, here's how we're going to police that. Here's who's going to be responsible for that. Here's what the whole system looks like. None of that was in place. And because none of that was in place, the whole system kind of fell apart. And so they recognized they needed something new. The League of Nations at this point had really collapsed. They needed a successor organization that was going to actually work, that would be able to keep the peace. When I was going through the archives at the Roosevelt Library, so I spent a fair bit of time at the Roosevelt Library. If you ever travel to the United States and have the opportunity to visit, I really encourage you to do so because it's fascinating and the archives are wonderful. And in the Welles papers, I came across this document, which was originally secret. You can see that's been crossed out. And this is a document that says Provisional Outline of International Organization prepared by JTS, who I'm nearly certain is James Thomas Shotwell, who I mentioned earlier was an advocate of the outlawry of war, was really in many ways the ghostwriter of the Kellogg-Briand Pact because he brought the idea to Briand. And he really wrote the message that Briand wrote back to Frank Kellogg. And he, in this document, this is the first page of a multi-page document, lays out what is, I think, the first draft of the United Nations Charter. It looks just like the kind of first effort at kind of putting the pieces in place that will become the United Nations Charter. So the very same person who was a ghostwriter of the Kellogg-Briand Pact also drafts the first draft of the UN Charter. And in this first draft, he actually puts right at the beginning, basically a copy of the Kellogg-Briand Pact in the early articles. That then becomes, after some revision, the Article 2.4 of the UN Charter. So Article 2.4 of the UN Charter says all members shall refrain in their international relations from the threat or use of force. So what's important to recognize about this is that that's an idea that's not entirely new to the UN Charter. Right? That's an idea that it's getting directly from the Kelly-Brand Pact. And it has the advantage of all these lessons learned from the mistakes made after the Kelly-Brand Pact, from the failure to put in place international institutions to enforce it, and to figure out what the rules are going to look like for all the rest of the system that's necessary to make it work. And so we wouldn't really have the charter that we have today and the success of the charter that we have today if we didn't have, in a sense, this effort to first outlaw war that really was not adequate, that didn't put in place all of the pieces that were necessary, and that we had had almost 20 years at this point of working out the rules by the time the UN Charter comes into place. Very limited exceptions that allow states to go to war. One is Security Council authorization. There's a whole process through Chapter 7 that Security Council can authorize a use of force. Self-defense under Article 51, so states, if they're attacked, are allowed to respond. And then it's not written into the charter, but most accept the idea that states can consent to use of force on their territory. So states can allow other states to use force to assist them in their own defense. Those are the exclusive exceptions. So remember that long list of reasons that states gave in war manifestos for going to war. There's a lot of reasons that are not on this list. The very limited set of exceptions, the only one that really continues in force is self-defense. And that seems to have really made a difference. So again, sticky conquest, once common, became rare. I showed you an earlier chart that shows that, but this is another way of seeing that recognized conquest. They were all recognized effectively in the old world order. During this transitional period, we see some continued conquests, but most of that snaps back. And a lot of it, there's a lot of territory conquered during World War II, but almost all of it goes back, so it's not sticky. And then in the New World Order, we've been lucky enough to exist in a world where conquest has become quite rare. Global deaths have also, it seems, fallen. We don't actually have data on this in the book, in part because I find this data on deaths much harder to document. And I think the data gets a lot worse the further back you go, for understandable reasons. But what this shows is a fair bit of decline in global deaths in the period, certainly in the UN Charter period. Fairly historically high level, kind of common for people to die in war. Obviously, the Second World War, First World War, and Second World War are highs that are match historical highs. But that since then we've had a decline, significant decline in global deaths as a result of conflict. This is another way of looking at it. Now, I think what's striking here too, and I'm going to say a bit more about this, but is that we see a significant decline in interstate deaths and interstate wars. We have seen a rise in civil wars, or what are sometimes called intrastate wars. And we've seen a rise in wars, intrastate wars with some interstate, with foreign intervention. So there has been a rise in intrastate wars, even as the kinds of wars that are prohibited by the UN Charter, that is wars between states, have really declined significantly. So this is, I think, generally a pretty rosy story. And yeah, I think that the story that we want to tell is this transformation has been extraordinarily important, has led to a much more peaceful world. But it's important to recognize, of course, that challenges remain. So one is from ISIS, which is motivated by an ideology that sees war with the West as a driving force. This picture here shows a man who's giving has a video where he's talking about the erasure of the border between Syria and Iraq, and he shows himself walking across the border, and sort of an effort at erasure of sovereign territory borders. That was a key rallying cry of ISIS. They don't hold territory any longer, at least for the moment, but continue to cause significant unrest throughout the Middle East and parts of Asia and other parts of the world. So that remains a serious challenge. The current conflict in the Tigray region of Ethiopia is one of several violent ongoing interstate wars. So there has been a rise in what are commonly called by political scientists intrastate wars, that is wars within states. This is something we talk about in the book, chapter that we call Why Is There Still So Much Conflict? Because there is still so much conflict, and a lot of it is now moved away from the illegal kind, that is war between states, to the kind that's not prohibited by the UN Charter, specifically that is war within states. And that is a real challenge I think we continue to face, and I don't think we've sorted out how to manage that yet. And it remains, I think, for those of you who are interested in thinking about conflict, that is the fundamental challenge I think we really do face today. Of course, many of the great powers, including the great powers that were fundamental in creating the UN Charter. So the Soviet Union was one of the key parties at the table when the UN Charter was created, but is now acting in ways that clearly contravene requirements of the Charter. So we have to recognize Russia annexed Crimea in clear violation of international law of Article 2.4, and the first successful conquest in Europe since World War II. And really, I think, concerning development in the modern era to suggest that Russia may not be as willing to provide consistent support for the UN Charter's prohibitions as maybe it once was. China has also laid claim to a number of disputed islands in the South China Sea. It has been building military installations on them. It's ignored an international arbitral decision against it, basically saying it can't do this. And it continues to act to build up these rocks, islands, and reefs into installations that it can create military bases on. And that's in clear violation of the Charter. Again, they're using force to establish control over territory, and that's clearly illegal. These are contested territories. These are ones where there's overlapping claims. But China, instead of letting that be decided by an arbitral body, has insisted on simply just moving ahead and constructing these installations in pretty clear violation of international law. And it's important to recognize Donald Trump won the US presidency in 2016 on an anti-internationalist platform. His rhetoric was all about rejection of the international community and rejection of international collaboration. And he made good on many of those promises. I won't detail it all here, but unfortunately, there was a lot of steps back in terms of global cooperation during his presidency. One key violation of the Charter's prohibition on the use of force was when the US, France, and UK carried out military strikes against multiple government sites in Syria in response to chemical attacks against civilians, but that was in clear violation of the UN Charter. It wasn't in self-defense. It wasn't authorized by the UN Security Council because Russia has consistently vetoed and made clear it will continue to veto any authorizations for use of force in Syria. And then in January 2020, Trump carried out a strike on Iranian leader Qasem Soleimani in Iraq, again, pretty clearly in violation of international law. So there have been violations, sadly, by the very states that helped construct the international order and the very states that helped write the UN Charter. Now, we're hopeful that Biden might reverse course. He certainly ran on rejecting this America First foreign policy and returning the US to the world stage and reconstructing the global order. And there have been some really hopeful signs. The recent G7 summit, there was a lot more sense of kind of coherence and cohesion among the nation states that are party to the G7, the kind of hopefulness about the capacity for engaging in global cooperation going forward. But I think it's impossible not to recognize that while Biden is withdrawing troops from Afghanistan, US troops from Afghanistan, he has continued to engage in some of the strikes where the legal justification is not entirely clear. So he struck Iran-backed militants in Syria twice and al-Shabaab forces in Somalia several times. And so far, the legal justifications for these strikes have not been entirely clear. There was an Article 51 letter in the first instance justifying the strikes as self-defense. And in the second instance, chances are good that it's under consent of the Somali government. But the lack of clarity about the justifications has led to a lot of questions. And And I am encouraging the Biden administration to try to be even more careful about its justifications and recognize the importance of the prohibition on force and not make the mistakes of following in the footsteps of the Trump administration on these matters. So despite these challenges, and I think we have to recognize there really are challenges, the story of the internationalists does offer real hope. So we see people like Levinson, Shotwell Wells. I said a little bit about them here. We really try to tell their stories in the book. And from them, we really can see that normal people, they really are pretty normal people with really extraordinary ideas, really can change the world. And to me, that is a really hopeful message that comes from the book. It also encourages me to think, and I hope you to think, that we can't take the world order for granted. We shouldn't just say, we've had an unprecedented period of peace since the UN Charter was put in place, and it's always going to be that way. That's not necessarily the case if we don't work for it. Each generation has to work to understand, maintain, renew, and improve the international legal order. We have to try and do our best to strengthen the global order so that we leave the world more peaceful than the one that we inherited. So with that, I'm going to stop the share and very eager for your questions.
Well, first of all, let me begin by thanking you for your very erudite address. And someone who belongs to this new generation perhaps notices that the grounds for war have shifted. Perhaps then you're missing you're really missing the woods for the trees. It's not land grabs anymore. It's cyber warfare, and it's warfare by rather political arm twisting. So then how would you reconcile with that difference?
Yeah, so I think you're right to note that we've been successful at ending one kind of war, and we're seeing a surge in other kinds of war. So it's important to recognize that there's some success in that, right? I mean, we should be thankful that we don't see much in the way of wars between states, because those are the most brutal, the most bloody, the most destructive wars. And so to the extent that the UN Charter and the international legal order that was put in place initially by the Kelly-Briand Pact and reaffirmed by the Charter has been successful, that's something to be celebrated. But we can't rest on our laurels, right? We can't say, well, okay, that's all we need to worry about, because yes, you're absolutely right. There have been ways that states have tried to work around those rules. So there's a number of ways in which they've worked around those rules. One way in which they've worked around those rules is that there's increasing work to engage in conflict by supporting non-state actor groups within other states. So Russia's support of Russian separatist forces in Ukraine is one example. US support for Syrian moderate opposition in Syria is another example. You can point to hundreds of examples around the world of support for non-state actor groups. This is not in direct contravention of the UN Charter, at least as currently interpreted, but obviously undermines the basic principle, which is you're not supposed to use force to achieve your ends, and providing arms and support and intelligence and air power to these groups is really kind of obeying the letter, but not the spirit of the law. Another example is the interpretation of self-defense. US, I think, has led the charge in excessively interpreting self-defense to allow a wide range of actions that, honestly, if you look at when they wrote the Charter, that was not what they had in mind when they put that into Article 51. So Article 51 actually says there has to have been an armed attack in order to give rise to a right of self-defense. And they had a fairly narrow vision of what that would entail. They recognized, and I try to weave this into the book, that many of those who are working in that period understood that defensive wars very quickly become offensive wars. And so you need to have a very constrained idea of what counts as a legal defensive war, because if every defensive war is legal, then you might as well give up on trying to prohibit war altogether, because every state's going to say that they're just engaging in a defensive war. All these balance of power wars that were done in the old world order were defensive wars, but they were launched against the state because it was getting too powerful. right? They called that a defensive war, but of course they weren't responding to any active threat. They were just responding to a fear that this other side might be getting more powerful. So that's another way in which I think we've headed down the wrong path. That is expansive interpretations of self-defense. And then a third area of real concern that you just mentioned is cyber. So cyber is an area where we're still really developing the laws that apply in this context. So there are cyber attacks or cyber operations where states do various things to interfere with their opponents. It may be something as simple as espionage, which is not part of the use of force, but collecting lots of information they used to not be able to collect. They may be engaging in various kinds of cyber vandalism. Thus far, most state cyber attacks have stayed below the Article 2.4 bar. So they haven't, this is what's called below the threshold. So the vast majority of cyber attacks have been below the threshold, that is below the Article 2.4 threshold. They haven't been an illegal use of force. The only one that is a kind of subject of debate these days is whether Stuxnet might have been a use of force. So Stuxnet, for those who may not recognize it, was a cyber attack reportedly carried out by the US and Israel against Iran that disabled centrifuges that were being used to enrich uranium for nuclear weapons. And the cyber attack basically caused these centrifuges to malfunction and break and caused millions of dollars of damage to these centrifuges, but nobody died. So the debate is causing these things to physically malfunction enough. So there's some debate about that. But that's the main one that people talk about as a possible 2.4 violation. None of the rest have been over the threshold, but there's been a lot of attacks that have been very troubling and that probably violate a lower international legal principle, that is a prohibition on non-intervention. So that are not a 2.4 violation, but are a violation of the prohibition on non-intervention. Part of the difficulty is that we haven't fully worked out exactly what the rules are for these below the threshold attacks. There have been some efforts at the UN. There's been some efforts to do something called the open-ended working group. They have been modest in success. They have succeeded in saying international law applies to cyber. So that's a step. But they haven't really been prepared to give a lot of specificity to that and say, okay, what exactly is allowed and not allowed? What exactly can states do and not do? And that's created this legal gray space that states have exploited. And Russia in particular, Iran in particular, North Korea in particular, probably the US, probably Israel, have exploited that legal gray space. And so that doesn't mean that the laws don't matter, but it does mean that you need to constantly be innovating. You need to be constantly responding to what states are doing. You need to be trying to stay a step ahead. Is a cyber attack less destructive thus far than a state launching a war against another state through kinetic means? Yes. Do cyber attacks have the possibility in the future of being equally destructive? Absolutely. And so we need to be really thoughtful about developing those rules, and we haven't gotten there yet.
I think that's quite interesting because we've now developed and we've reached a phase wherein environmental damage is now considered as a crime against humanity. So perhaps we're not far from thinking of cyber warfare as one as well. That being said, one other reflection I wanted to share was that self-defense in cases like the Soleimani killings by the US, there is some sort of a legal justification or an international legal justification that is given for that, that perhaps suggests that the US is not as ambivalent as it at least used to be in the days of Nicaragua. The other question I had is really based on discussion, or rather a debate, which I saw between Fareed Zakaria and Neil Ferguson, and the topic was on the international legal order. And what Ferguson furthered was that this world order that we live in is not really by international organizations. It's really based on a theoretical and political homogeneity of military alliances and a particular thought which we further, which is really based on the remnants of the Cold War. So is it actually based on these military alliances that war has considerably reduced? Perhaps this is a direct reference to Article 5 of the NATO Charter, or is it actually international organizations which have taken the front in peace?
Yeah, so it's a great question. So just to your first aside, I think is an interesting point. So you're absolutely right that the fact that the U.S. is at least offering Article 51 justifications is a step in the right direction, right? And the Trump administration, even when it engaged in the Soleimani strike, did provide an Article 51 letter, and that's important because that gives us something that we can look at. We can assess the arguments. We're not left kind of guessing. We can find the arguments are not sufficient and not justified, but at least there are arguments being made, and that is an important step, because there's states who engage in what are questionable legal actions without taking that step, and that's a really important point to make. And I think you're right to at least recognize that that's an essential first step towards moving in the right direction. On the role of international organizations, I mean, I think the thing to recognize is these international organizations like NATO, for instance, are really important. There's no question. It's not that they aren't important. They are really important, but they're organized around a set of principles that are put in place first by the Kelly-Brand Pact and then by the UN Charter. So what are those principles? So Article 5 of the NATO treaty provides that if any state is attacked, the rest will come to the defense. Well, that is articulating the idea of collective self-defense and self-defense, which is permitted in the Article 51, and is providing a kind of reaffirmation of the idea that you're not allowed to attack us, and if you do attack us, we're going to collectively respond to it. In ways that we're legally permitted to do. There's nothing in the NATO treaty, for instance, that says, hey, if you violate our rights in some other ways, like you fail to repay debts, like we can collectively go to war against you, right? So that is, there's nothing in there that's inconsistent with the charter obligations. And in fact, in many ways, these alliances, these organizations are built around the set of principles, the foundational principles put in place by the charter. And then these other organizations exist to support and reaffirm and make effective those obligations. And they are important. That's not to suggest that they aren't important, but they're giving life to a set of legal principles that exist in the charter. And that's essential. They're not inconsistent with it. They're entirely consistent with it, and they're affirming and supporting it. And that's it. That's exactly what you want in an international legal order, is for these organizations to be coherent and consistent with the fundamental legal principles of the international order established by the UN Charter.
I can agree with you there. Another, perhaps the last question which I would like to raise is, in preparation for this discussion, I did see other discussions which were done on this very topic, and your co-author, Professor Shapiro, made a reference to military spending and the increase in the US Senate on that. So that sort of got me wondering, is that if the United States or any other country which is a super capitalist structure, can it wriggle itself out of this malaise of military spending in a democratic structure? And my reasoning here is as follows. Companies guarantees jobs, and in the military spending, especially in the US, this is spread across the whole country. And a Boeing or a Lockheed Martin actually advertises this very strongly. So if the companies guarantee jobs, and if the politicians also guarantee jobs, and if this defense contracts or these defense spending is severed, then jobs will be lost. And the linchpin in all this is the politician. So will the politician actually destroy himself in the name of peace? And peace, which in the American perspective is understood as defining in this construction of self-defense and a preparation for preemptive strike. will then lack of preparedness or peace be an alternative that they can consider as politically or even economically viable, given how deeply the corporations have sunken their fins in defense through preparation and job creation?
Yeah, that's a really powerful question. And I do think that you've put your finger on something pretty fundamental, which is that there's a huge infrastructure built up around the military, not just in the US, but in countries around the world, but particularly US, which is the largest military industrial complex in the world. And a lot of politicians, this is crucial for them. There's, defense contractors are a lot of money, big jobs, no doubt about that. I'll add to that the arms trade. The US is one of the biggest makers of arms and sells them around the world. So it's not just for US defensive purposes, but it's funding militaries throughout the world. And I think you're right that creates a kind of inertia towards additional military spending, towards not providing limits on production of arms and selling them abroad, although there's some limits. I think it's a really powerful question, and I wish I had a better answer to it, other than I will say, what you are seeing, at least in the US, is a lot of people who are just incredibly tired of war right now. And I think if you're going to be able to push back against these pushes in favor of military spending, you have to have something on the other side, something affirmative on the other side. And the something affirmative on the other side can be the rise of people who say, like, wait a minute, what are we spending all this money on? Like, is this really the best use of our funds? Do we really think that it's best for us to be engaged in war in the Middle East for more than 2 decades now? And you're seeing more of those questions being raised. The US Senate just voted to repeal the 2002 authorization for use of military force, which is mostly a defunct rule, but has been cited by some administrations for some operations in the Middle East. So that's a step in the right direction. And politicians, I think, got the message that there's a desire in the American people to wind down our involvement abroad, to end what's sometimes referred to as the forever war, and to invest that money back at home. A realization that this is not a costless choice, that when we're spending money on military operations and drones and sending forces abroad, we're not spending that money at home on education, on healthcare, on things that really make an important difference to ordinary people's lives. And we're also spending the money abroad on military weaponry and training instead of, again, education, foreign assistance, other kinds of things that can make the lives of ordinary people better. People like me make that argument a lot, and it is beginning, I think, to have an audience. You're seeing more people recognize this. You're seeing more politicians speak about this, and a kind of recognition that war, endless war, is not in our national self-interest. It is, of course, in the interest of some of these defense contractors. So again, you need a voice on the other side, and that's why we need to encourage democratic participation here in the United States of people who believe in peace, want to end the forever war, and are asking their politicians to do that. That is, in the end, what is going to make the difference.
Perhaps you need more figures like a Lauder Pact or that ilk, because those are really seminal figures, and you've perhaps also highlighted them. Let's take it a bit further. We need more Professor Hathaways to do this, and perhaps generate more jobs for international lawyers, because I think peaceful settlement of disputes is the real answer, and it's cheaper as well. So you save money that way. Well, Professor, it's been an absolute honor and a privilege to have this discussion with you. I give the floor back to you for final words, and we can close the session after that.
I just want to say thank you so much for this. And you're right that part of the reason I enjoy getting the chance to give these kinds of talks with you, with your students, is to encourage people to think about the role that they can play in bringing about peace. and encourage them to think about the importance of the prohibition on war and the role that they can play in enforcing that and encouraging it and providing support for it. So I hope that that this has been persuasive to the audience. I hope you all take away from this some sense of the importance of the UN Charter and its prohibition on force, and why it is that in our work, in our studies, and in our personal lives, we should do what we can to support the UN Charter and this key prohibition on force. So thank you again so much for having me. It's really been an honor, and I wish you all the best of luck.
Thank you so much, Professor.
Thank you.